We are live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you. We welcome you to the Wednesday, December 2nd, 2020 settings of the 7th Court of Appeals, appearing through Zoom. And I'm glad that we have this opportunity to appear and address cases before us. We want to thank the attorneys for appearing through Zoom. Things have changed this last year, and we've had to stay nimble and imaginative. And so far, we're getting through it. And I'm sure that we'll only improve. We have one case this morning. I will go on and call the docket, and given that you are here, we will assume that you're ready to proceed. And the case that we have is 07-20-00027-CV, J. Michael Ferguson, PC, and others versus Ian Ghrist and others. And Mr. Ferguson, I see you are ready to proceed, correct?
Yes, Your Honor.
And Mr. Ghrist?
Yes, Your Honor.
Am I pronouncing your name correctly?
It's Ghrist.
I'm sorry?
Ghrist?
Ghrist? Ghrist. Well, thank you, and I apologize for the mispronunciation. I am not sure either one of you have argued in front of the 7th Court of Appeals. I imagine you've argued elsewhere, but the court is prone to ask questions. Please do not interpret those questions as indicating a particular decision having been made. We often play devil's advocate and want to flesh out issues. And in asking questions, we ask that you answer them as directly as possible to save time and save us from asking follow-up questions just to clarify things. Of course, the appellants have 20 minutes and the appellees have 20 minutes as well. And the appellants have an additional 5 minutes, and you're welcome to take your entire time or as little time as you wish. With that, we're going to turn the floor over to Mr. Ferguson, since you're the appellant.
All right. Thank you, Chief Justice Quinn. And if it please the court, this is a case that started out what we felt was a simple case of a fraudulent signing of a release of lien and a partial release of judgment. And the case it got out of hand, in my opinion, and we're here today. But one of the most important issues that we feel has presented itself during this case is the two camps of how this can affect attorneys and the profession of attorneys. In one camp is in protecting the attorney-client relationship and not disclosing confidential information and privileged information. And the case that we've used mainly for that is Burroughs versus ours. The new case.
If I may intervene, there are two actual lawsuits, aren't there? This lawsuit and a sister or companion lawsuit?
There was one in the 17th District Court, Your Honor, that took place prior to this one. And then during that lawsuit is when the release of lien and the partial release of judgment were signed.
And are you seeking to have the record in the other lawsuit in the 17th District Court made part of the record here, or are they utterly separate?
I think they're separate because the issues were not in what's being tried in this case was not tried in the 17th District case. And to me, they're just completely separate.
Okay, so you're not trying to incorporate the record in the other case into this one?
No, Your Honor. May I proceed, Your Honor?
Yes, sir.
Okay. And as I was stating, the other thing that we feel is important is the second part attorney immunity, that attorneys should be able to aggressively represent their clients without fear of being sued. And this is sort of what's happened in this case, in that Mr. Ghrist represented Anson Financial, JMFPC, and the other entities. And so that's where the slap actions came. But dealing with the first issue of the fraudulent release of lien, Your Honor, there was a,
Can I ask you to intervene again? I'm sorry.
okay,
Opposing counsel indicated in one of his last points in Apley's brief that we lack jurisdiction because your motion for new trial was untimely, therefore your notice of appeal was untimely. What do you say to that?
Your Honor, we filed a document that had some papers were turned wrong or something, and it was rejected by the system. But under the Texas e-file instructions, the court is supposed to accept it of when you did file it. You can correct whatever the document that caused the glitch to reject it. And we filed that with our motion for permission to file it late. And we filed that only because it wasn't date stamped the right date, but under the Texas e-file rules, if it's rejected because of a glitch, then it can be accepted as of the day you actually filed it.
Now, you're saying that as the document you filed, the motion for new trial, that was rejected or something else?
The motion for new trial it had an exhibit that was turned wrong, or it was too large, and it was rejected. There were 4 pages that we had to reprint as a PDF, reattach it, and then they accepted it.
Will the record that we have reflect that something was filed but was rejected, that a motion for new trial was filed within a timely period and it was rejected?
Yes, Your Honor. It was filed at the same time that we filed the motion for new trial on the 20. Appellant's motion for new trial, that would have been filed, Your Honor, on 10/16/2019 is when it was filed, and that will be part of the record. And I think that's at court record starting at 2563 is where the motion for new trial, and it will be right after that.
Page 2563 of the
Yes.
court record?
Yes, Your Honor.
Rather long record. Okay, thank you.
Yes.
Mr. Ferguson, your first 2 issues deal with the trial court's rulings on the motions for summary judgment. With regard to your first issue, what cause of action did your motion for traditional and no evidence summary judgments apply?
We were filing against Mr. Ghrist for the fraudulent signing of the release of lien that he signed, and he signed it that he was a member of MBH, and we were suing to establish that he was not a member at the time that he signed it and has never been a member, and then that's what we were trying to establish.
In looking at your notice of appeal, I did not find your indication that you were appealing from the trial court's denial of your motions for summary judgment. Can you direct me in the record to where you've included that?
On the notice of appeal that was filed, well, there was only one notice of appeal, Your Honor, and that would have been filed.
Was that the one that was filed on December the 3rd of 2019. It would appear that you're appealing 3 different orders, but I don't see where you're appealing the trial court's denial of your motion for summary judgment, which was encompassed in your first issue.
Well, the trial court, when they did the final order, they included all of that. And that was on separate.
Was that in the order of severance?
There was an order of severance, and then there were multiple orders in which, and then on September 17th is when the court signed the, or the 16th. So order. I think that was on September 16th is when the order on appellee's motion to sever and making judgments final is at court record 2543.
Thank you.
May I proceed?
Please, Dick.
Okay. All right, as far as on the issue of whether Mr. Ghrist was a member of MBH, we're stating that and arguing that we'd have to go to the Texas Business and Organization Code to determine that. And if we look at the formation documents that was filed, and we put that as appendix, exhibit 1 in the appendix, Mr. Ghrist was not on the formation documents. It was just Mr. Coker and me that were, or J. Michael Ferguson PC that were on the formation documents. And if you go to Texas Business and Organization Code 101.103, it states that in connection with the formation of a company, a person becomes a member of a company on the date the company is formed if the person is named as an initial member in the company's certificate of formation. And Mr. Ghrist was not.
Can they become a member afterwards?
You can become a member afterwards, yes. And that's under section B. It states that a person being admitted as a member of the company but not named an initial member of the company's certificate of formation becomes a member of the company on the latest of the date the company is formed or the date stated in the company's records as the date the person becomes a member of the company, or 3, if the company's records do not state a date described by subdivision 2, the date the person's admission to the company is first reflected in the company's records. And there aren't any company records that reflect, it's undisputed that there was no operating agreement. And so Mr. Ghrist was not ever named as a member in any of the company documents that were filed. And Mr. Coker was a client, and we had the lawsuit in which there was a contingency contract, and Mr. Ghrist was involved in that lawsuit, and that's what this is really about, is the dispute that arose out of that. And then when we got into a dispute, Mr. Ghrist left, and there was a separation agreement that was signed. And then later on, Mr. Ghrist got with Mr. Coker, and they decided that they were going to try to take the loans. And that's where the main dispute started. And Mr. Ghrist did not disclose to anybody that he was representing Mr. Coker. And he helped negotiate the settlement of that settlement agreement between Coker And nothing was ever mentioned during that settlement. And $650,000 was paid to settle not just the lawsuit piece of it, but there were other companies that were involved in this. And Mr. Ghrist never stated anything about that. And we went ahead and closed, and then Mr. Ghrist came back and sued later and stated that he was a member of the MBH when it was done. But what he used as evidence at the time of the trial, or the motion for summary judgment, is he stated which is under court record 1642 and 1643, is first he stated that the jury charge from the 17th District Court gave him a 13.33% ownership in MBH and or in those lawsuits. But ownership does not equate to being a member. You can assign a membership interest and still not be a part of the entity, and that's under Texas Business Organization Code 101.108. And an assignment of membership interest in a limited liability company is not an event requiring winding up of the company, does not entitle the assignee to participate in the management and affairs of the company, to become a member of the company, or to exercise any rights of a member of the company. So Mr. Ghrist was stating that he became a member either through, I guess, an assignment, which there is no evidence of there ever been an assignment, or that the jury gave him ownership in this. But the Texas Business Organization Code states very clearly that that does not give you the right to be a member and have management of the affairs of a company. He may have right to profits or something, but he doesn't have any rights to sign anything.
Mr. Ferguson, I hate to set us back, but I'm sort of lost factually about how MBH came about. Is that a vehicle that you created for the purposes of the settlement? I'm lost as to how MBH was created and why.
Okay, Mr. Coker and I had other entities, a Dragon Gas and an entity called MPI Anson, in which we shared other assets. And that would be the exhibit, another exhibit that Mr. Ghrist used to saying that he had ownership, which is under court record 3213 and 3214. And in this, it's an email dated June 6, 2015, in which Mr. Coker and I discuss what we're going to do to establish, to merge all this into one company. And, but it was just an email between Mr. Coker and I, and in nowhere in there did it talk about MBH real estate. In fact, it was talking about a trust that we would establish, in which under paragraph 1 in the email, it states that we would establish a trust in which you or whichever entity you designate are 60% beneficiary of, and J. Michael Ferguson PC or whatever entities I designate will be 40% beneficiary of the trust. And then it goes on to state that we've attached copies of things. And then on page 2 of that, it shows the other companies and the assets that they have, and that we would do that. And that is on June 6, 2015, and MBH had not been formed at that time. And that's what Mr. Ghrist used as his part of his evidence to establish that that was a company record. But nowhere does it have MBH. Next, he states that the agreement that we had when he separated gave him his membership interest, and that was another exhibit he used. and that's under court record 3218 and 3219. And in here, it lists out multiple matters that were still pending that we had together. But under paragraph 14 specifically on page 1, it states that Mr. Ghrist would be due 13.33% stake in MBH Real Estate LLC. And nobody is disputing that Mr. Ghrist has a right to 13.33% of the net revenues that came off of that. But his agreement was not with Mr. Coker. It was always with J. Michael Ferguson PC. And he was to get money after J. Michael Ferguson PC got that. And so those are the items that Mr. Ghrist used as evidence to establish that there was a company record. And he also attached that, in addition to that email, it's Defendant's Exhibit 61 that was used in the 17th District Court, which is under Court Record 1664. And that's just a long list of items that we were reporting to Mr. Coker at the time. And it hasn't got anything to do with MBH Real Estate, and MBH Real Estate had not been formed at that time. So there is, once we bought out Mr. Coker, then he assigned the judgment to MBH Real Estate that was a part of that lawsuit. And his interest in MBH was assigned to Anson Financial. And Mr. Ghrist represented Anson Financial at the time and was also the receiver in this issue. So at one time, he was representing all parties at the same time. And that's one thing that we're asking the court to consider in these actions that were filed, in which the SLAP actions were the response. We were trying to protect our confidential information and our rights from our attorney that was representing us, and he felt it was okay to disclose this information and failed to disclose that he had conflicts or get any permission in writing or anything before he represented the other parties.
And are you referring now to your third issue, which alleges trial court error? And I'm just wondering what that error is, because your issue seems to frame it in terms that there was a breach of fiduciary duty, but I've not found in the record where any court has ever found breach.
Well, and they haven't, Your Honor. That's one of the things that we are stating that we're having a problem with, is that the breach is that he's representing all clients. Under the rules of professional conduct, he is supposed to come to Anson and say, hey, I'm going to represent Coker. But if he represented Anson and Coker on the same issue, then he would be conflicted out. No court, I mean, I'm at a loss of words of what to say today about how you can sit in a jury trial and testify that it's okay to do this and there's no ramifications. So that is the
trial that was before a different district court and not the appeal that we're here about today, correct?
That's correct. But even in this court, in the 141st, it was talked openly about each of these issues, because each of the SLAP actions was, we were trying to get him to stop dealing with clients of J. Michael Ferguson PC, in which he had worked on those matters while he worked for J. Michael Ferguson PC. And so that was under issue 3. In our opinion, he breached the rules of professional conduct by not disclosing that he was going to represent all parties. He was still the receiver. So he had, once Anson MBH took an assignment of the judgment, then under a Chapter 32 receivership, Mr. Ghrist was representing MBH at that time. And so that would be a conflict of interest. And that would be a breach of fiduciary duty is what we're arguing, Your Honor. And for each of these, I know I'm running out of time, so for each of these issues, though, that on the SLAPP actions, that is what those issues were. We were trying to get the court to stop him. We filed a motion for temporary restraining order, and we were denied
Actually,
that.
Mr. Ferguson, you're not running out of time. You ran out of time.
Okay.
And we asked Judge Parker if she has any other questions or if Judge Fertile has any other questions.
No, sir.
Sir.
Thank you. You of course, you have 5 minutes rebuttal after Mr. Ghrist. And with
Okay.
that, we'll turn it over to Mr. Ghrist.
Thank you, Your Honor. So I filed a motion to transfer the record from the Second Court of Appeals in the 17th District Court case into this court, and that was denied on I forget the date, but Mr. Ferguson was not requesting that. That was being requested by me. We submitted those records to the trial court. There's the record of another proceeding or judgments or anything in the docket from another proceeding is something that the court can take judicial notice of, and we would ask that the court do that. I also provided a hyperlink in the attachments to our brief where that record could be downloaded. I was told by the clerks at the Second Court of Appeals that they can easily transfer that record through a software system if the court decides to look at the record.
What's the need for that record, counsel?
I'm sorry?
What's the need for that record here?
To look at the res judicata claims and whether they should have been dismissed on the basis that they could have been litigated in the 17th District Court. Mr. Ferguson referred earlier to the fact that I believe he said, openly talked about what occurred in the 17th District Court. That's because we actually litigated these issues in the 17th District Court, and then he attempted to relitigate them in this court, which was something that the trial judge had a big problem with, and which was the primary basis for the claims that were dismissed on the summary judgment motion that I filed.
The trial judge in this case from which this appeal emanated, did he take judicial notice of these records in the 17th court case?
I don't think there's going to be a statement on the record where he stated that he was taking judicial notice. We did talk about those records, but I don't believe you're going to find a reference in the record where he states, I am taking notice of this. You'll just find discussions of, I'm sorry?
Is there anything in the record to indicate that he formally admitted them into the record of this case?
No, there would not be any formal admissions because it was all on summary judgments or SLAPP motions, which are all decided on affidavits.
Well, both of them have evidence. I mean, you can attach exhibits and other evidence to both of those. If there's nothing in the record to indicate that the court formally accepted those as part of the record that it was considering in rendering the orders from which this appeal ensued, can we consider that record?
Yes, Your Honor, I believe so. We talked about it at the hearings. It was made available to the trial judge. The record will show that he did consider it.
Okay. Thank you.
And I don't believe on either summary judgments or SLAPP motions that there's a need to have the judge announce which documents he's admitting. I think that typically you would submit objections, and then if you don't get a objection signed off on by the trial judge, then it's considered part of the summary judgment record.
So on what basis did the trial court consider the record from the 17th District Court?
In connection with the res judicata claims.
Right, but what was before the court that he considered?
Well, the issue would be whether those claims could have been, in the exercise of due diligence, litigated in the 17th District Court.
I understand that. I guess what format, was it part of your motion for summary judgment? Or what format did the trial court in this case have to consider the record from the 17th District Court?
Oh, I see. I spoke with the trial court's clerk who told me that the judge has access to that through the Tarrant County electronic system. But I also shared a Dropbox link with the court where they could download the entire record as well. But I was told that they did not actually need that in order to review the record because they use the same system that the Court of Appeals uses. Was that the what was being asked?
Well, yes, I was just wondering in what format and how do we know if the court considered the other case and what portions of the record in the 17th District Court did the court here consider, or did the court consider in your summary judgment motion?
I see. The record of the hearings on that would show what we discussed and which portions. The pleadings were a big part of it. However, I think the pleadings may also have been attached to the summary judgment motion as separate exhibits rather than just referenced in the record. I will have to double check on that. But the pleadings were definitely a big part of it.
Well, the pleadings are somewhat confusing. In the case before the court, there were several non-suits by Mr. Ferguson throughout the case.
Yes, Your Honor. There were several of the claims that were litigated in this case that were pled in the 17th District Court and then non-suited there and refiled in this court, then later non-suited again after the slap motions were filed.
Well, in answer to the issue brought by Mr. Ferguson with regard to res judicata, and collateral estoppel, he claims you've waived those issues by not addressing them in you waited until your first amended answer to address them. Would you like to elaborate on that?
Yes, Your Honor. As soon as this case was filed, the 17th court case was pending at that time. Shortly prior to this lawsuit being filed, many of the claims that were included in the original petition in this lawsuit were included in the pleadings in the 17th District Court. So they non-suited those claims there and then filed a new lawsuit here. And then we filed the first anti-slap motion almost immediately afterwards. And that was appealed. As soon as a slap motion is appealed under the rules, there's a stay of all activity on the case. During that stay, due to the appeal, the 17th court case went to trial. And as soon as the stay was lifted and the mandate was issued, we immediately, I believe within less than a month, filed affirmative defenses for res judicata and collateral estoppel because the 17th District Court case had gone to trial while the first slap motion in this lawsuit was on appeal. I also cited cases, including a Texas Supreme Court case, saying that as long as those claims are added before the case is resolved, the trial judge has broad discretion to allow those to be added. So it's going to be an abuse of discretion standard. I also pointed out that at the time those claims were added, there was no trial setting. And
And what claims were added? Are you speaking about your affirmative defenses? Are you speaking about the fourth supplemental petition that Mr. Ferguson filed?
when I said claims, what I meant to refer to was the affirmative defenses.
Okay.
At the time that the affirmative defenses were filed, there was no trial setting. There was the discovery period had just started because the lawsuit, while the lawsuit was stayed, there cannot be any discovery. So the lawsuit had only been pending for, I believe, less than 2 months without the stay. If you excluding the stay, by the time the claims were added, there was no surprise to the other side, or there's ample time to prepare to submit a response to the res judicata and the collateral estoppel issues.
And those affirmative defenses were in response, were raised in the summary judgment setting,
Yes, that's correct, Your Honor.
and they were reflected in amended pleading, amended answer.
Yes, the answer was amended after the 17th court case went to trial to include res judicata and collateral estoppel.
Did Mr. Ferguson object to attempt to amend your pleadings to add those, or did he object to your allusion to them in the summary judgment setting?
Just in the response to the summary judgment motion, I don't think there was any objections besides the response to the motion.
Now you say other than a response. In his response, did he object, or did he claim that they were waived in response to the summary judgment motion?
Yes, you'll see arguments in the court record where it was discussed in front of the trial judge, and I believe it was also in the document.
In his response?
Sorry, the response, yes.
Yeah, thank you.
Because I know we talked about it, I'm sure it came up. Regarding the motion for new trial that we talked about earlier, I'm not primarily alleging that the issue is that there was an issue with the filing, with it being not accepted, because I believe the rules were revised to provide that as long as you can show that it was submitted, even if it was submitted incorrectly, you still have to go by the original time frame. The argument that was being made there is that the deadline to file notice of appeal was not extended because the orders that he was filing a motion for new trial on were signed more than 30 days before the motion for new trial was filed, because those were interlocutory orders. I think the case law is clear that your notice
You have to file a motion for new trial for an interlocutory order?
I believe you do have to file a motion for new trial on an interlocutory order if you intend to have it. Now, the judge has plenary power, so the judge could consider a motion late, but I don't think it would extend the deadline for the notice of appeal unless it was filed within 30 days of the date that it was signed.
So you're suggesting that if you have a partial summary judgment order and it's interlocutory and no final order has been entered, you have to file a motion for new trial on that partial summary judgment order in order to timely appeal.
In order to extend the deadline to file an appeal, that would be our position.
Can you appeal from an interlocutory partial summary judgment order?
No.
So why would you need to file a motion for new trial when you can't appeal for that order, in order to perfect appeal when you can't appeal from that order anyway?
Well, you'd still be able to appeal. You just would have the normal time frame.
You'd have to appeal.
And you would have plenty of time to get your arguments on file. Since
You'd appeal when there's a final order entered.
You would have to wait until the final order was entered to file the appeal. Yes.
Okay. Okay, thank you.
The appellant has also brought up an issue with regard to your attorney's fees as far as your being a pro se litigant. Tell us how you're entitled to attorney's fees in that capacity.
Yes, Your Honor. Well, first, there's no case law that would state that you cannot recover attorney's fees as being a pro se litigant. In this case, there was evidence submitted of invoices from my law firm to myself that are currently due and owing. And that
Can
debt,
a pro se litigant who is not an attorney, who represents, well, of course, pro se represents himself, recover attorney's fees?
who's not an attorney? No.
Okay. And do you know why they can't recover attorney's fees?
I believe because they're not licensed to practice law, and
Could it be because they didn't hire an attorney?
right.
Did you hire an attorney?
Yes, my law firm is also a defendant, and then my law firm hired me to represent it on this case. And that's a debt that would be relevant to my creditors, my heirs. It would be relevant in a bankruptcy proceeding. I understand that I do own the law firm, but they are separate entities, and there is a debt there.
Okay.
And that debt would be relevant in other contexts as well, above and beyond just myself and the fact that I do own that firm.
Counsel, did your records comply with the latest Supreme Court guidelines with respect to the lodestar, your hours billed, and I mean the number of hours, reasonable rate, that sort of thing?
Yes, Your Honor.
You
I
broke
know
it
that
down.
there's the Rumos case. I assume that's what you're referring to, which
I never
is
can pronounce that.
very, and I don't know if I'm pronouncing it correct, but it clearly requires itemized billing on basically a day, at least a daily basis, and that is all reflected in there. There's
So in this case, you actually went to the trouble of billing yourself and keeping track of your time and records.
I did, and because of how many hearings there were several different updates to the billing records, but you'll find that they're itemized. Each day it will state the number of hours, a reasonable rate for those hours, and a detailed description of the work that was done.
How does that work into the order of sanctions? The court considers sanctions sort of in the same light that it is to compensate a party for what they consider the inconvenience of litigation. The final issue is the unconstitutionality of the award of sanctions.
Understood. Some of the case law we cited suggests that sanctions can be a multiple of the amount of attorney's fees. However, that it doesn't have to be that. That's just one way that courts use to try to determine an amount of sanctions to award. There's one case we cited that has a non-exclusive factor list that could be reviewed to determine the amount of sanctions to award, including the net worth of the defendants, whether they're sophisticated. In this case, the plaintiffs were all owned and operated by an attorney, Mr. Ferguson. But your question was related to the attorney's fees and how they relate to the sanctions. And there is some case law to suggest that one way of determining a sanctions amount is looking at what multiple of the attorney's fees the sanctions could be. And as to the constitutionality, I couldn't find any cases to suggest that there's anything unconscionable about the TCPA requiring sanctions or that sanctions being awarded. all of the case law that was cited related to punitive damages awards, which is a different thing entirely.
Why would it
And
be different? It doesn't say,
I'm sorry.
doesn't one aspect of sanctions serve to punish and stop conduct?
It could be, yeah.
There's
There's a deterrent factor.
Does punitive damages serve that aspect as well, to punish and stop conduct? To punish
I
conduct?
believe so.
So is the case law related to the constitutionality of punitive damages analogous to sanctions? Or can it be, in your view?
Well, in this case, I don't think so, because it was only 3 times the amount of the fees awarded. But I suppose if the sanctions was $5 million or $100 billion, it could be a different situation. I wasn't able to find any suggestion that the constitutional limits on punitive damages also apply to sanctions, but I imagine there would be some limits in a case where the amount was extreme.
I think my last question took you past your time. I'll ask the other judges if they have any questions.
No,
Thank you, Mr. Ghrist. We're going to go on and go back to Mr. Ferguson and hear if he has any rebuttal.
Thank you, Your Honor. I was just going to clear up a couple of things. You had asked me about the order on the motion for new trial and the order on the timely filing of the motion for new trial. That's actually under the court record 3334 and court record 3336. And I think I gave you the wrong one. The only other issue that I was going to bring up is on the res judicata. Mr. Ghrist is saying that these were tried in the 17th District Court, but again, the only issue that was tried in the 17th District Court that he got a jury instruction on was whether he was an owner of, he had ownership interest, and that is not going to be, I'm going to give you the.
But wasn't there one cause of action related to fraud or fiduciary duty or something along that line?
On fiduciary duty, yes, Your Honor.
And
In
was
the
there-
17th District Court, we did have, but in this case, the fiduciary
were
duty.
the underlying grounds for that cause of action similar to the underlying grounds of the cause of action asserted against him in this case? His representation of NBH, et cetera, breach of not disclosing representation.
As to Coker, yes, Your Honor, it was. As to the other clients that he's interfered with, no, those were not tried at all in the 17th District Court.
Well, does res judicata actually require actual trial, if you will, or just the possibility of being tried because they have a similar factual basis?
Well, with res judicata, at the time that the violation or the breach occurred, if it was before the answer was filed, then yes, it would, that could be counted. But in this case, all of these actions took place after the answers were filed in the 17th District Court. And so they would not be a part of that as res judicata or collateral estoppel.
So you say answers, you're talking about the initial answer?
I believe that's right, Your Honor. Once the original answer was filed in the 17th and then events that occur after that, then that would not be, if it's a new event, then it would not be res judicata in the other case. And
So you're saying it's
especially if
different-
it's different parties.
You're saying it's different underlying facts then?
Yes.
Okay. Okay.
And the only other thing I was going to just say is just the ownership under the definitions in the Texas Business Organization Code state that, you know, ownership does not give you the right to be a member. And that's also in the definitions. And I've lost my place where it was at, but, and that was also stated in 101, they can't be. So in the 17th District Court, the real issue was ownership is what he asked about, not if he was a member. And so that was the only other thing that I was going to bring up. I appreciate it. And that's all I have, Your Honor.
Do any of the judges have any questions?
No, sir. Thank you.
Thank you.
Thank you.
Thank you both, counsel, for appearing through Zoom. Hopefully you're staying safe. Hopefully you're adapting to the situation. It's good to keep us on our toes by changed circumstances, even though they can be frustrating at times. But we have the ability to adapt, and we have the mind for it. So we will continue adapting to proceed forward. With that, we will be in recess. Your case is submitted, and you will be hearing from us in due course. Again, thank you, and have a great holiday.
Thank you, Your Honor.